All right, what's going on, great people? I am your most hated host, JV the Great. And when I say the most hated, it's only by a select few, mainly within the XRP community. Now, I used to consider myself a part of the XRP community, but I call myself trying to be helpful and trying to raise people's awareness and present to them the documents that were being presented to the judge by the SEC. Now, a lot of those documents during the discovery phase wasn't in the best interest for Ripple. And contrarily, a lot of people didn't want to see those documents. It showed Ripple's, um, how can I put it, transactions and got in depth about the ODL and how really ODL partners were really selling XRP just as soon as they received it. And also showed how Ripple had to buy it off the secondary market in order to keep the price from plummeting. Now, today, there was a filing. I haven't read it yet. I haven't glanced over it. This is going to be my first time actually looking at it, and it was on Twitter. Attorney Falon initially posted it, and also John Deaton and his um, company Crypto Law, they also added it, and it's Ripple's supplemental authority in support of the fair notice defense. Now, John Deaton here, salute to John Deaton. John Deaton here, he quoted it, and also let's see what he said about it. A lot of people are speculating on why Ripple. Hold on, guys. A lot of people are speculating on why Ripple would file this now. Some people are saying it's because Ripple knows it will lose or because they're less confident. It's a very simple reason why it was filed. The decision is from the Supreme Court and it was handed down only 4 days ago. Now let's get into the actual documents. Let's see here. Please zoom in. We'll do the 2-page view. Present. But I don't want to do the 2-page view. So let's get out of there. Let's go back. Let's get out of that. Now, let's get into it. All right. And it goes, Dear Judge Torres, defendants Ripple Labs Inc., Bradley Garlinghouse, and Christian Larson respectfully submit this notice of supplemental authority relevant to their opposition to the SEC's motion for summary judgment. On February the 28th, 2023, the Supreme Court decided, what is that, Bittner versus United States, number 21-1195. In an opinion by Justice Gorsuch, the court reversed a decision by the Fifth Circuit that had held that the Bank Secrecy Act authorized a $10,000 penalty for each foreign account that an individual failed to disclose, rather than for each report that the individual failed to file. In a section on behalf of himself and Justice Jackson, Justice Gorsuch elaborated, and I'm probably messing the name up. Anyway, elaborated on the requirement under the due process clause for the government to provide fair notice of what is prohibited. Now, stopping there, let's see here. Stopping there. there was a point where there was a point where all of the attorneys, all of the lawyers within the XRP community were saying we should hope that it doesn't get to the fair notice stage. Now, this filing seems to be in support of the fair notice. Now, if it gets to fair notice, then that only means one thing, that Ripple is on the losing end, and they now have to pay some type of fee. They're going to be fined, and there's going to be some type of disgorgement. Now, I don't see how this is in favor of anything they have going on, but we're going to continue to read, and we're going to see how this thing plays out. The rule of lenity exists in part to protect the due process clauses promise that a fair warning should be given to the world in language that the common world will understand of what the law intends to do if a certain line is passed. And the government current theory poses a serious fair notice problem. The relevant provisions of the BSA nowhere discuss per account penalties for non-willful violations. A number of the government's own public guidance documents have seemingly warned of per report, not per account, penalties for non-willful violations. We are even told that until 2008, 2009, when the government began aggressively enforcing F-bar penalties, many experienced tax professionals and return preparers were not aware of the F-bar reporting obligations, let alone aware of the government's current theory about the scope of penalties for non-willful violations. If many experienced accountants were unable to anticipate the government's current theory, we do not see how the common world had fair notice of it. Now, that's a good argument in regards to not knowing the rules, not knowing the law, in regards to cryptocurrency and how you can sell it. But like I said, if they're at the point now to where they're now wanting to fight, they're now wanting to aim all of their focus towards the fair notice, then it seems to me that maybe they're losing confidence in their case. I know they've spent 100 million plus on this case now. Maybe they're coming to terms that, hey, maybe we did violate the law. Maybe we did violate security laws. Maybe we shouldn't have financed our company with XRP sales after we got gifted 100% of the supply of XRP. You know, maybe they're coming to terms with that. If not, why would they be focused on this fair notice filing? You know, leaves one to wonder. And not only that, but sorry guys, not only that, but also on Twitter, Stuart Alderati, who is Ripple's I think their lead attorney, he was saying something that this case is, he's very confident in this case going to what's the word I'm looking for, that they will appeal if they lose. And he's very confident in the Supreme Court's decision on this case if it gets that far. So it's like they're trying to change the narrative now that hey, they're bracing everyone that, hey, we might take a loss initially. Just hang on because we're going to appeal it. But I personally don't believe that even if they appeal it, I mean, at the end of the day, you guys still sold a hell of a lot of XRP to finance the company Ripple. I don't think anyone can get away with that. You know, and that's not throwing salt on Ripple in any kind of way or being negative, but that's just the truth of the matter, that we're in the reality, people. if you create an asset, cap number of assets, right? 100 billion, like 100 billion XRP, you keep 100% of the supply yourself. You distribute it amongst the founders, CEO, or whoever else, a certain percentage, and then you give 100% of the other 80% to your company, and then you distribute it to exchanges to allow for speculative trading. Not only you do that, but you maintain a hefty supply, put it in escrow while also selling that asset to finance the company. I mean, let's be real, people. Let's be real. I hope Ripple wins in some kind of way because our country desperately needs innovation. But I don't think this is how it's going to get. I don't think this fight is going to happen now. That doesn't go against secondary sales, because I think ultimately secondary sales of digital assets, cryptocurrencies, are fine, but it's still tough to say with Ripple's situation because they started out with 100% of the supply and they distributed it using market makers and incentivizing exchanges and all this, that, and the third. So it's kind of hard to say which way the judge is going to lean on this matter, but summary judgment is coming up any day now. Maybe the end of the month, but any day now, we'll see. On that note, man, y'all let me know in the comments, hit that like button, hit that subscribe button. Y'all let me know, do y'all think Ripple is going to win